We are live streaming. Good morning. Welcome to the First District Court of Appeals. We have several cases on our docket this morning. One is going to be argued, and that case is McLean versus the Drinkery. Mr. Matthews is here on behalf of Appellant, I see, and Ms. Robison is here on behalf of Appellee. Mr. Matthews, you will have 15 minutes to argue. Would you like to reserve any of that time for rebuttal?
No, Your Honor.
All right.
Expect to use the entire 15 minutes.
All right. Whenever you're ready, you may begin.
Okay. First of all, I am operating under the assumption that everybody is familiar with the facts and the law that apply to this case. I did not take the opportunity to file a reply brief because I believe that both briefs that have been filed clearly set forth the law, which is really pretty clear and not in dispute in any way. In my mind, the issue in this case is totally factual. Are the facts such that reasonable minds could come to a conclusion that is different from what the trial court and the appellee believe they show? It's obvious to me that the facts, at the very least, are so unclear as to require that a jury should have been given the opportunity to make a decision. As the court knows, where reasonable minds can come to a different conclusion, it's a matter that should be subjected to the decision of a jury or a trier of facts. In this case, it's my opinion that the hazard that was present there's no doubt that was discernible or visible. The question is whether it was such that a reasonable person could appreciate the nature of the hazard. And I would suggest to the court that this is not a situation where appellant encountered, for instance, a set of rickety old steps and decided to take a chance to climb those steps and they caved in on it. Rather, this is a situation where there were a set of very heavy slate pool table slabs sitting on their edge benignly, and for some reason they fell on the plaintiff and broke her leg. The question is, again, there's no doubt they were visible. The question in my mind is, were they such that a reasonable person could have appreciated the hazard there and avoided it? There were no warnings posted. There was nothing there to keep.
Counsel, these slabs were pretty large, weren't they?
They were very large.
Okay.
The record does not show how large they were because they were gone by the time anybody.
There were photos with the deposition.
There were photos, yeah. There are photos, and the photos, I would submit, they are very large. They're also very heavy. There's no evidence as to how heavy they were, other than the fact that it took more than one person to lift them off a plaintiff's leg after they fell on it. But yeah.
Is there a dispute of fact as to what caused them to fall in the first place?
I think so. There was an affidavit filed. Well, first of all, the plaintiff testified in her deposition that she rested her wrist on the slates. She had first removed some glasses that were bar glasses that were sitting on the edge of the slates. She removed those without any consequence. At some point, she kind of rested her wrist and hand on the edge of the slates, and that's when they began to fall on her, she said. I believe that appellees attached an affidavit at some point from someone who claimed that plaintiff had more interaction with those slates than just resting her hand on them. And the implication being that plaintiff did something to cause them to fall. And again, to me, that's where you've got a genuine issue as to the material facts. I think there's no question that, as I said before, the slates were visible, but I don't think that any reasonable person could have appreciated the fact that they could be a hazard.
Did she appreciate, is there evidence in the record that she appreciated the fact that they were heavy? I mean, could she tell that?
I don't think there's evidence. There is evidence in the record that, and I can't remember whether it was plaintiff or an affidavit from her friend she was with, but that they appear to be drywall as opposed to slabs. And appellant felt like when they started to fall, she testified that she did try to push them back and realized that there was no way she could control them because of their weight. And so she,
How many were there?
I think 4 or 5 perhaps. I'm not sure about that, and I don't know that that was ever clearly established in the record.
So your client thought they were drywall, like 4 or 5 drywall slabs?
She felt they were something like that. She felt like when they started to fall, and I don't know if she knew what they were, but she felt like when they started to fall, she could push them back and keep them away from her. And she quickly realized that they were so heavy that she could not control them. So she stepped back and obviously didn't step back or didn't get out of the way quick enough.
So your argument for the open and obvious is that the weight of the slabs was not open and obvious.
Essentially, my argument is that the slabs were obvious. If she saw them, there's no question they were obvious, but or were visible. The question is the dangerousness of them was not obvious. And I think that's where the open and obvious test, it creates a genuine issue of material fact. Were they obvious, or was the hazard they presented obvious to her? And my argument is that it was at the very least a question that should be decided by a jury.
What case did you cite that was, so the cases that you cited in your brief, most of these cases deal with hazards that were not seen. And so your argument here is like she saw the hazard, she saw the size of the hazard, she just didn't appreciate the weight of the hazard. And I'm wondering if you can point me to like the best case in support of that you have.
Well, let me look here. Okay, there's one case I cited, I think, that holds that this is not a case where the hazard is undisputably discernible. Rather, a genuine issue of material facts remains regarding the open and obviousness of the hazard, such that summary judgment is not appropriate. And I believe that's the Baumgartner versus Walmart Stores Incorporated, which I cited in the brief.
Let me ask you a follow-up question to that, Mr. Matthews. These, when she encountered them, were leaning or at least up against a wall. If we use the facts that are undisputed and make reasonable inferences from there, I'm still struggling as to how in the world these would have fallen to begin with. And is that not obvious? I mean,
well, Judge, I struggle with that.
Is it obvious that they would fall, or is it a more reasonable inference that they wouldn't fall?
Well, I don't think there's an answer to that question. The photograph that is part of the record shows that they are leaning. There's no question they're leaning, but it's not
leaning in though.
Leaning in, but
towards the wall.
But not.
So how would they fall backwards?
I don't know. I mean, they weren't leaning in at a great angle, but people had access to them. They didn't fall, but for some reason, when my client came in contact with them, they did fall.
Well, she rested her arm on them, right?
She rested her arm on them, she set her wrist in her hand. Again, there were other people that had contact with them. They did not fall. Obviously, people had contact with them in some fashion because there were bar glasses on there. But sometimes,
is there evidence in the record that other people rested their arm or wrist on these and they didn't fall?
No.
Okay. Or touched them in any way?
No, there's no evidence in the record that anybody touched them other than my client testified that she removed bar glasses. So obviously somebody at least set those on top of it. It's one of those things where stuff happens. My argument is that they should have never been there in the first place, or at least there should have been some warning provided to stay away from them. And the fact that they fell for some reason makes it clear that there's there's an obvious danger, there's a hazard there. It wasn't obvious to her at the time, but it was open. So I don't have much more to say other than, to me, it's something that a jury should be given an opportunity to hear all the facts and decide. I don't think it's so clear cut that there is no genuine issue.
Thank you, Mr. Matthews. Ms. Robinson, you have 15 minutes.
Good morning, Your Honors, and may it please the court. My name is Danielle. I'm representing Urban Sites Property Management and GBG Strategies. As you know, it's arising out of a September 27 incident where these metal slates are falling or did fall on Ms. McLean's leg. The trial court properly granted summary judgment in this case and barred recovery against my clients. And I kind of will know.
Ms. Robinson, just one question of clarification. They were metal?
Well, they're pool table slates, and I want to go ahead and bring, I think it's also in the record. I think the site is, find the exact site, TD46 at 158 to 59. There are the pictures attached from the deposition transcript. This is, I think it was Exhibit B.
Yeah, I'm looking at it.
Okay, good. That shows these slates. There wasn't clear indication that they were metal, but based on the visibility of the slates and knowing that they were pool table slates that go under, I'm submitting to the court that they're kind of this mixture texture of like a concrete metal type of slab that goes under pool tables to make sure the pool tables remain even.
Let me ask you this, if that's true, and again, I'm not sure that's in the record, so I'm not sure we can rely on that, but they were obviously very heavy at the end of the day, but was that weight obvious to people who would encounter those slates? In other words, would you realize by looking at them that if they started to fall, you couldn't stop them?
So I submit to the court that it would be, specifically in this case, not only is it clear that they were going to be of a heavy nature based on the texture of the slates, but also the fact of their height. I think Ms. McLean testified in the record that she ends up lifting up and putting her hand on these slates, and they're at least torso height. And I think the picture also does a pretty good job of depicting how tall these are, in comparison to other things around them. There were,
but if they're that heavy, then how did they fall? By just, you'd have to hold them, wouldn't you?
So there is the indication that there would have to be some sort of pull coming from them. And when that comes to mind, I like to bring to the facts of the record that Ms. McLean did have 8 alcoholic beverages before this incident occurred. She, of course, did not admit on the record that she was, pulling on them in any sort of the fashion. But there's also the law of gravity in place, and an object in motion stays in motion, object in rest stays in rest. And so I think that a reasonable inference could be made that there had to have been some sort of leaning or pull upon these for them to be able to fall. And also going back.
Counsel, in the brief on page 6, it says that Ms. McLean actually leaned on the slats. I couldn't find that anywhere in the record where she admitted to that.
I don't recall everything from the exact deposition. I remember her specifically admitting to touching the slates,
yes.
And resting her hand on them. I don't think she admits to pulling on them. As to the specific word lean, I don't have it offhand as to where that was in the record. I know my site has us around 55 to 57 and page 132 of the deposition transcript. But that's the best I can speak to that. I also think that it would have been appreciated based on the fact, the hazardness of the slates would have been appreciated based on the fact she walked up to these slates, took glasses off of them, I've been thinking of an analogy. I think I was hanging shelves in my bathroom, and you kind of know when something is resting on any type of surface beneath it, you know, how much weight it's going to support when you're putting something on and taking it off. And so for that, you know, analogy, I kind of submit to the court to think about when she was taking the glasses off of the slate, she could at least have appreciated and recognized it was holding 4 glasses that were from other patrons at some point in the night, and had the opportunity as she was taking those glasses off of the slates to appreciate the texture of them, the size of them, you know, how much weight they were holding from those glasses alone.
But
Also,
counsel, since if a reasonable person should have appreciated how heavy they were,
Mhm.
wouldn't it be reasonable to believe that because they were so heavy, they wouldn't fall?
Even if taking that as true, I feel like if you're appreciating the danger of how heavy they were, you should have been avoiding that in the first place. And that's what the open and obvious doctrine is about, not necessarily relying on the fact that they're not going to fall.
Well, but
So-
under that theory, then nobody should have been standing at, let's say they're 6 feet high. Well, they're not that high, 5 feet high. Nobody should have been standing within 5 feet of it then. Is that what you're saying? That anyone who saw it would know that they were heavy, that they could fall, that you wouldn't be able to stop them from falling. Therefore, you'd need to leave a clearance of 5 feet. And so that nobody should be standing within 5 feet.
I mean, sure, if you're seeing these things, you know, I wouldn't have myself gone up to them. Maybe other people shouldn't have been in their presence, but I think the facts of this case make us focus on whether or not my clients had a duty of care to owe a plaintiff in this specific situation. And the argument is that they didn't owe a duty because the open and obvious doctrine doesn't require them to have that duty based on the nature of the slates being such a hazard and noticing them.
So are they open and obvious just under the facts of this case because she actually touched them previously, or would they be open and obvious to anybody, as Judge Myers was saying, that was standing near them?
I would argue that they are open and obvious to everyone, but even more so in this particular set of facts. You know, opposing counsel is trying to argue the visibility isn't enough. And so we're adding the fact that she did have the opportunity to appreciate their danger by going up to them. I don't think the record specifically says she touched them when she's taking the glasses off of them, but you're certainly very well aware of their durability, their durability of them underneath of them as glasses are being held on top of them. And when
She touched them at one point.
Yes, and she did touch them at one point as well. Yes, exactly.
She touched them. So if I remember the transcript properly, she says that she rested her wrist and her arm on them, and then, as she put it, they began to move, which moved her wrist. Correct?
Yeah, that was her testimony. And I'm submitting to the court, again, just the nature of the law of an object in motion stays in motion. An object in rest is going to stay in rest unless acted upon. And so to me, it's her nature of putting her hand on the slates is what ends up causing movement, because she's also testifying to the fact that she sees space in between that brick wall and where the slates are leaning. It's clear that they were resting sideways and had to be moved, you know, in the opposite direction to go downwards in the other.
So she doesn't really know until she rests her wrists on them, according to your theory, that they're heavy. But by then they're already moving.
Well, I think that would be plaintiff's theory or Mr. Matthews' theory, that she's not recognizing how heavy they were. My argument is that she would have recognized how heavy they were just by seeing their texture, noticing their height. They are like an inch thick, it looks like, from the pictures depicted. And there's, I think, 3, maybe 4 of them there. And again, height, touching them, all of that taken into consideration in this in these facts in this case, give her that opportunity to certainly appreciate their danger.
But
So-
I'm still,
Go ahead, Judge
Yeah,
Myers.
Judge. I'm still confused. I mean, they're not leaning like this, but they're leaning like this. For them to fall, even with that leverage, if they're as heavy as they are, how does that even happen without somebody grabbing and pulling them? That's the danger that I'm trying to figure out whether it could be appreciated.
So I will be clear, I don't think anyone or the record knows exactly how heavy these were, but clearly they were heavy enough to cause a fracture to Miss McLean's leg.
Well, and so heavy that she couldn't push them back.
And couldn't push them back up. Yes,
And
you
that
are
it
correct, Your Honor.
required more than one person to lift them off her. So,
Yeah.
Presumably more than 100 pounds. I would
Yeah.
guess.
So, and again, I think I just want to keep pointing to the facts of this case, that Miss McLean had 8 alcoholic beverages before approaching these and before the lien started. I think that we had an expert at some point, and I think it's in the trial record that discusses the effects that alcohol can have on you after having that many alcoholic beverages.
Over what period of time?
I think it was a period of 5 hours. She started at 8 p.m. at Cock and Bull with 2 drinks in it. And of notice, the important thing is 4 drinks were consumed within the hour leading up to the event. She arrived at the drinkery. She ended up, I think, testifying to having 3 drinks as she walks in the bar, 2 mixed drinks and a shot. And then 2 shots and a mixed drink, because she took another mixed drink out to the back patio with her. She finished that 4th drink on the patio in the back. And that's when I think she was taking all of those empty glasses. So that last drink was, consumed and fully finished, I think, as right before this incident had happened. And so I think that with those facts taken into consideration, I think the direct answer to you, Judge Myers, is that I'm presenting the argument that the touch and the lien, I'm inferencing the lien because I'm not sure if the record does state that she's testifying specifically to quote unquote leaning on them.
She actually explicitly denied that.
Yeah, from touching the slates and then them falling on her.
But she'd have to be leaning outside. She'd have to be leaning on the side, not directly in front of them.
Yeah, I think she.
Then it wouldn't have fallen on her leg.
Well, what happened was she touched and then she turned her body sideways to try and stop them, and that's when they fell on her as she was. That's why she was in front of them at that point. She did say that her side, I think, was right next to the slates, and that's when she first touched, but she moved and pivoted her body to be in front of them to try and catch the fall. I'm trying to look and see if there were any other questions.
So Ms. Robinson, opposing counsel suggested that they might have been drywall slats or something that wouldn't be as heavy. Could any reasonable person look at those and think that they were materials such as drywall slats? Somebody who's not familiar with pool table slats or building material in general?
Sure. So I think I do think it's fairly common that a reasonable person knows drywall is usually white, and it looks fairly different than what these metal texture looking slates look like. I don't think a reasonable person would pull together that these were pieces of drywall. I also think, and I'm not even that super familiar with drywall, but just my understanding is the one, the color, they're white. 2, it's usually a smoother surface. I do think these pictures, it's a little bit tougher, but I do think it's pretty clear to indicate that they have I kind of almost relate this to like a chalkboard type texture that looks more metally and concrete like. And so I don't think a reasonable person would presume that these are in any of the sense drywall like material.
And you have about 1 minute left.
Thank you, Judge. I think that we've hit on most everything that I want to talk about. And I just want to reiterate that it is our position the trial court properly granted summary judgment. These slates were in open and obvious danger that Ms. McLean could have appreciated and failed to do so. So thank you for your time today.
Any other questions from the panel? Thank you both very much for your arguments this morning. We will take the case under submission and give you a timely decision. That will conclude the oral arguments this morning for the First District Court of Appeals.